Good morning. I'm Robert Kimball, a partner in the Capital Markets and Merger and Acquisition Group at Vinson & Elkins. My pleasure to welcome you today to the Navigating Series, which is a webcast series designed to assist our clients and our friends of the firm in navigating the new normal here, the pandemic-related issues, industry dynamics, rapidly changing social or business or legal norms. Our focus today is going to be navigating the 2022 annual meeting and reporting season. So, it's customary in these programs to begin with a joke, but one of the things we learned during COVID is that opening monologues at late night television shows fell very flat without an audience that was well primed to laugh at them and get us to laugh at home along with them. Our marketing group absolutely refused to give me a soundtrack, a laugh track, an applause track, any kind of track. So we're going to have to kind of skip the jokes. We've salted a few of them in, but they're all courtesy of the SEC, and they're not very funny either. I have with me on my right, Catherine Frank, who is also a partner in the Capital Markets and Mergers and Acquisitions Group. And on my left, Scott Rubinski, another partner in the Capital Markets and Mergers and Acquisition Group. And our first panel today will address SEC disclosure updates related primarily to your 10K. We will have a little bit of a break at around just before 10. And at 10, we will have another panel with focus on annual meetings, shareholder proposals, and proxy advice. We will then slide directly from that into a discussion of environmental, social, and governance matters with a little bit of a transition to bring another member online in each of those panels. We will then take a brief break at 11, and our final panel will be an ESG discussion panel that will be hosted by Maggie Peloso. So that's our agenda for this morning. You will have two scheduled breaks, and we will try very hard to stick to that for you. So with that, I believe, Catherine, if I can turn the time over to you.
Excellent. Good morning, everyone. We're glad to have you attend. Since the SEC has been so busy over the past couple of years, we thought it would be helpful to start this presentation with a quick tick through last year's updates and maybe a few insights on how we've seen issuers respond to those updates or disclose related to those updates. So starting at the top, these should all be fairly familiar to you. We'll begin very quickly with the updates to Item 101 of SK that were effective last year to the business section. A couple, high-level updates there. The SEC moved to a more principles-based disclosure in the business section and also gave issuers the opportunity to move to an updating model where they would have the opportunity to incorporate by reference a more fulsome business description from prior years as long as a hyperlink was used. And just want to flag for you guys that has not been the trend among our issuers and public companies at large. Really, that can raise some problems when it comes to incorporation by reference in the future. So we would expect that incorporation by reference or hyperlink of the business section really to be used in registration statements, maybe on S1 or S4, and for that to be where it's most common, as opposed to just including the fulsome business description in each 10K every year. The second Item 101 of SK update from last year was the requirement to include discussion of human capital resources in your business disclosure. And since this has become an area of heightened interest and sensitivity, we're going to touch on that more extensively in our ESG discussion later morning. The other item, excuse me, in item 101, which is just a reminder that your regulatory disclosure about regulatory effects on the business should be expanded merely from environmental regulations that affect the business to all material government regulations that might affect your business. So we have seen and expect to see that expanded regulatory disclosure and to see that updated annually.
Catherine, wouldn't you say that most of our issuer clients that we see, we're already doing that?
That's true. That's true. And we've seen everyone revisit that disclosure last year and expect them to revisit it again. Maybe expand a bit, but yes, that was common practice before as well. One other change that went through last year was the updates to legal proceedings, item 103 of SK. The SEC explicitly allowed a practice that had been fairly common before, which was allowing companies to hyperlink or cross-reference their legal proceedings disclosure to other parts of the document, namely the financial statements. There's one thing we want to remind you of as you work through that and make a decision whether to hyperlink, which is that the disclosure rules for item 103 and then for your financial statements do differ slightly. So make sure to work through with your auditors this year and through your legal counsel to make sure if you are going to hyperlink that you're meeting the requirements of both sections. And the other update in legal proceedings is that the threshold for reporting environmental proceedings has been raised from 100,000 to 300,000. We've seen most companies adopt that higher threshold or move very quickly toward that higher threshold, with larger companies moving toward the $1 million threshold that's allowed by the SEC as the upper limit of a reasonable threshold for materiality. Finally, I want to move to item 105, the major updates to risk factors from last year. This is just your reminder to work through your risk factors again this year. If you were to add risk factors and they were to expand past 15 pages, you're required to include a summary. Don't forget that this year. And make sure you're looking very closely at your COVID risk factors, your cyber risk factors, and anything else that is of particular interest for the company this year.
Climate change risk factors.
Climate change risk factors, for sure.
And we'll touch on those a little bit later.
Yeah, those will be topics later in the program.
Right.
Thanks, Catherine. Will you take us to the next slide? Perfect. So continuing on with some previously implemented changes, as you all probably know, the SEC put out guidance last year regarding disclosures of the effects of COVID on companies, businesses, their liquidity, their capital resources. So we would expect to continue to see disclosure in your reports this year regarding the effects of COVID. Many of you last year probably included or focused your disclosure around government shutdowns and the ability for your employees to get back to work and things like that. We're expecting to see less in the way of government shutdown disclosure and more in the way of how COVID is affecting things like supply chain, labor shortages, and things like that. So we do still expect to see MD&A, risk factor, forward-looking statement, all those sorts of disclosures regarding COVID, but expect it to transition a little bit from the way that a lot of people talked about it this time last year. We also will get into this a little bit later in the presentation, but we would also expect some folks are going to consider the impacts of COVID on their non-GAAP financial reporting, and so we'll touch on that a little bit later in the presentation as well. MD&A, there were some changes, or the SEC released some guidance regarding MD&A, mainly reminding issuers to include key performance indicators and metrics in their MD&A section, and also to disclose all the material information that an investor will need that will facilitate an investor's understanding of the key performance indicators that management is including. And then lastly on this slide, the SEC amended the rules regarding financial disclosures in connection with the acquisition or disposition of a business, both historical and pro forma financials. And that's another topic that we'll touch on a little bit later in the presentation. Keeping with previously implemented changes, last year, many of you who have registered debt probably included as Exhibit 22 a list of your subsidiary guarantors, and you'll need to do that again this year. We'll touch a little bit later on this topic as well, but electronic signatures, the SEC amended its rules to permit the use of electronic signatures on many documents filed with EDGAR. So that's going to be a little more convenient for folks to get those documents signed, particularly in a remote work that many people are still in. So we'll talk a little bit about what's allowed and how that will work later on in the presentation. With regard to your 10K cover page, there will be an update to add to that as well. There's a new box that should appear on the cover of the 10K, indicating whether an internal controller or financial reporting auditor attestation is included in the filing. And so be sure to include that box on the cover page and check it as appropriate. And then lastly for this slide, the SEC altered the thresholds for smaller reporting companies to become an accelerated filer or large accelerated filer and increase the exit thresholds as well. So we'll touch on a number of those topics later in the presentation, but that's just a high level overview of some of those previously implemented changes.
So the way we've set up this morning's session is that we've broken it into 3 blocks. Stuff that already has been adopted, much of which you should have done last year, but it's amazing how things like adding the box to the cover sometimes gets missed. So we've really just put up those slides for you to use as a quick checklist to run through. Have we implemented this? Did we do that last year? Whether we did or not, let's remember to do it this year. We'll slide into another section of stuff that will be coming into effect applicable to this 10K with a similar summary approach you can use as a checklist. And then we'll shift to upcoming pending rulemaking that we just want you to be aware of and keep your eye on and be able to answer questions when you get those from your executives or others within your organization. So this is a rule, the redaction rule has been a great improvement, and perhaps I shouldn't editorialize, but you will see a pattern here that stuff that was proposed or adopted 2020 and before, a fair amount of that seems to be a little more facilitating to companies and reporters. And then beginning in the change of administration, we have an undoing of some of those, although not all. There's some clarifications that were positive and good, and then a movement toward additional regulation. So there's a shift that we've been in during COVID of attitudes at the SEC. And this is one of the best things I think they've done in a long time. Basically, the Supreme Court said that the competitive harm standard that's been in the case law for decades, and that you had to show in a confidential treatment request that you'd suffer competitive harm if certain information were disclosed. Supreme Court said that's not a part of FOIA. It's gone. You just have to show it's not material, and it's the type of information that the company both customarily and actually treats as private and confidential. So you've got more flexibility to redact and defend that. The other thing that was great is you don't need permission from the SEC up front. You just file your redacted exhibit. You have an unredacted exhibit available to submit to the SEC. On request, you have a legend, a prominent statement you have to put on the first page of the exhibit. About the redactions, you put stars or a bracket in stars where the information has been omitted, and just make sure that your exhibit index also says you've got redactions there. The SEC, when this first went in, did send letters to companies asking them to provide the unredacted version to them, and there were some review and comment, but you get to kind of start with the presumption that you're allowed to redact these things if you meet these standards. Don't go crazy with it. Okay, use good judgment, because like many rules, if it gets abused, then we're going to get pushed back the other way. But it's a great improvement in the process. So that will, and by the way, that obviously didn't apply to your last year's 10Ks, but you really should be looking at it for any new exhibits that you were filing last year in your Qs, if you're a calendar year filer, and certainly any new exhibits for your K. That's where you really get the benefit.
Another beneficial change were the SEC's edits to the acquisition financial statement rules. Any of you who have been acquirers, or if you've disposed of significant assets, know that acquisition financials of the target or of the disposed business, as well as related pro formas, are required in the 201 closing 8K for those transactions, and then often in related proxy statements and in registration statements filed after the fact. The SEC adopted rules in May 2020 that revised the income and the investment tests that determine significance, and generally those changes have been beneficial to issuers. They've made the rules apply a little bit more consistently, especially in companies that have net loss or are close to zero net income. And it also revised the treatment of multiple acquisitions of individually insignificant businesses, so that you only have to provide aggregate information for those businesses in registration statements. The real takeaway here, however, is although these rules were passed or were fully effective last year or the year before, the SEC has not updated the Corporation of Finance Reporting Manual, the CFRM, to reflect these rules changes. So if you plan to dispose of or acquire a business, and particularly if you're a serial acquirer, we really do recommend you work in advance with your auditors to determine exactly what financial statements will be required, what your deadlines will be, and to work in advance of signing to make sure that you have negotiated the provision of those historical financial statements from your targets, so that you can comply with those deadlines.
Another beneficial change that occurred a little over a year ago that we encourage you to take advantage of is the authorization to affix electronic signatures to documents on behalf of people, whether that's through a DocuSign type software or through email. You do have some document retention requirements that are set forth here. But if you haven't done this yet, we really do encourage it. We always are running into the director that's on his boat off the British Virgin Islands and only has ship-to-shore access for voice communications, once every couple of days, or we seem to have a few that are the sole remaining people in the United States without a scanner at their cabin. And so these things will help, at least to the extent that they can connect to the internet wherever they are. One of the issues that's come up about electronic signatures is the use of email, and whether or not that's a logical or digital credential that provides the appropriate authentication. And we think best practice, although you could get there even without this probably, but best practice would be to have an express statement in your authorization that allows the use of the email they have on record with you, or maybe they put it in the authorization, so that email communications there and from that address are the ones you can rely on. I think a little bit about when you use email, making very clear that your transmittal email authorizes, has them responding to a clear request for authorization to affix their electronic signature to a document. And since a lot of people just distribute signature pages, to affix the signature page to the document in its final form. So please put that on your list, doing that if you haven't already in one of your board meetings, your officer meetings over the next couple of months. I think you'll find use for it, even if ordinarily you're still going to collect manual signatures.
Another area that's changed and something that you'll definitely want to be mindful of as you schedule out your reporting schedule for the year is filer status. So filer status is still tested the last business day of the second fiscal quarter. So for year-end companies, that's the end of the second quarter, so around the last business day, around June 30. And the changes that were made here are around the treatment of smaller reporting companies and whether they're accelerated or large accelerated filers. For a company eligible to be a smaller reported company that has revenues of less than $100 million in the most recent fiscal year, they're no longer considered accelerated or large accelerated filers. So they'll have a little extra time before they'll have to make their 34 Act filings. However, a smaller reported company with a public float between 75 and 250 million and $100 million or more of annual revenues would still be an accelerated filer, and so would still need to file on the accelerated timeline. The rules also increase the thresholds to exit accelerated and large accelerated filer status. The accelerated filer threshold went from 50 to 60 million, and for large accelerateds, it went from 500 to 560. So definitely worth rechecking your math if you haven't already to make sure you know what your filer status for the coming year is and that you get your filings in on time. This next slide, I won't go through these thresholds, but this is just another example of us including a table to sort of use as a checklist. If you can kind of take a look at your public float at the end of the second fiscal quarter and your annual revenues for the most recently completed fiscal year and determine which of these statuses you fall under.
All right. In with the new, here's what's required going forward this year in 2022. So again, this is our checklist slide. We will hit into most of these further, other than item 301 and 302. So the new SK rules that will be applicable to your upcoming 10Ks. Item 301, selected financial data, gone, eliminated, no need to be included going forward. Item 302 of SK, supplementary financial information, has been replaced with a principles-based requirement for material retrospective changes. We expect that to mean it's effectively eliminated for most filers. Item 303 of Reg SK, MD&A, we'll talk about that more deeply since that is really the meat of the SK changes for this filing season. Moving to the stock exchanges, and we'll hit on all of these in more detail, but a reminder that if you are a NASDAQ listed issuer, your proxy statement or 10K must include a board level diversity matrix in the NASDAQ's preferred form. You do have a little bit of extra time to provide this disclosure, but anecdotally, we're hearing that it's going in everyone's proxy statements. So make sure you take a look at that and it's on the list to include. The NYSE has edited its votes cast standard, and instead of using what we used to call the NYSE votes cast standard, has deferred to the company's governing documents and applicable state law. And then the NYSE, for our NYSE listed issuers, has gone back and forth a few times on their required treatment of related party transactions, and we'll talk about that a bit.
So MD&A, we've already mentioned that there was some guidance from the SEC to put more information about the management's metrics that are in there and to expand discussion to make it more helpful. They have that was guidance. They've got specific rules that are in effect for this season. The first one is really just a codification of about 32 years of SEC interpretive releases relating to MD&A, where they've now codified some of the key principles and layered on this principles-based disclosure over MD&A generally to help readers see the company through the eyes of management and to disclose known trends that are likely to have a material change in the future unless management can reasonably conclude that the material effect is unlikely to happen. So things we've talked about for 30 years, but were in guidance, and you were encouraged, but not necessarily subject to any kind of sanction, have now shifted to where they can have more teeth if they really think you're not following the principles they put in there. They do mandate critical accounting estimates into your MD&A. They really want us to enhance our discussion of liquidity and capital resources, particularly our cash requirements, your capital commitments. Even though they've taken out, you'll see the table for obligations, contractual obligations, is a mandatory table. They've still said if it's material, you ought to be discussing that as part of your general MD&A. One of the things that's kind of interesting, it's on the slide we just left, but let's stay where we are, is they've said that you can compare interim periods either to the comparable period of the prior year or sequentially. And I'm curious whether we see people go purely to sequential and not worry about the corresponding year, or whether there's still going to be enough expectation from the market and analysts and others that those who want to do a quarter-over-quarter comparison will still also be doing a quarter to prior year quarter comparison in addition to that. But certainly in the entry into COVID and coming out of COVID, the quarter-over-quarter would make a lot more sense because you were comparing to pre-COVID years. And coming out of COVID, comparing to the heart of COVID, assuming that that's where we were and not where we are, has a lot of logic. And then there are a lot of other companies that just because of the nature of their development, the prior period just may not be that meaningful. So it's one to talk about, but think about whether you're really in a dual reporting world if you do that, and make sure that you've got a little feel from who's covering you on that. And of course,
Robert, it's interesting because I think, in my experience at least, a lot of companies included in their earnings release already a comparison of the sequential quarters. So it's interesting to see them allowed to do that in the body of MD&A as well, to be more consistent with the approach a lot are taking.
Yeah, but now we'll complain about it because they're telling us we have to, right?
That's
Before,
right.
when it was voluntary, we were good
right.
citizens, but they're taking away our good citizenship by compelling it.
That's right.
See, so we've got that issue. But while we're talking about MD&A, though these slides are later in the deck, we ought to note that MD&A is still the most commented on section of people's filings. The number one comment area. And some of that is because it picks up a lot of the non-GAAP stuff that gets a lot of attention. Some of it is just because there's a lot of routine disclosure out there still that doesn't really explain. It says, well, it changed from this to this, but it doesn't explain why it changed. And a good MD&A, I think you step back, management steps back and says, what happened? What are the high-level things that we want to flag? And a nice little bullet point of those up front is good. But why are they happening, and what can turn and go wrong on us? That's not just purely a risk factor, but stuff that we're anxious about and worrying about. And of course, significant M&A during the period fits in that. Price volatility, if you're in a price volatile environment, can do that. People that are suddenly not able to reopen stores enough, or restaurants enough, or don't have the staffing for their business enough. What are the key issues? And if there were some significant things, you did a private placement of preferred to an institution to fund liquidity. Step back, talk about that. Think about how you're going to explain that and your choices, almost like you're taking them into the boardroom. Think about how much you can and should say so they understand why that's what you did and that's the path you chose and went down, and it'll reduce a lot of questions. So that front part of MD&A, I think, even though in recent IPO companies it tends to be a summary rehash of the business, it really should be a summary of what's going on and what your condition is, and what your key issues are and your key trends are. And then you can get into some of the detail of some of those later on. Again, don't forget that if you're dealing with non-GAAP, as many do, you are in an SEC filing and you're under the 10E rules, GAAP first, GAAP first, GAAP first. And hold your guns on that. So, you know, the SEC's commented a lot on this. We've got a slide that summarizes that back on about slide 38 or so, and we'll let you read through that a little bit when we get there. I guess the other thing we should comment on, because it'll be a theme throughout, is there were a lot of comments from the SEC about the effects of COVID, and you mentioned that, Scott, but you know, be realistic about what those are and how those have changed over the last quarter, 2 quarters, year, certainly from last year. You know, what are the ongoing effects? And are they really still COVID related, or are they something else that we're now blaming on COVID? Because it's a great excuse. Mom, I can't do my homework. I'm too anxious about COVID. Yeah. So just, you know, work through those issues. What else do you think would be really key for people to remember as they write their MD&As this year?
I will say I saw a lot of descriptions of COVID effects that were put together in first quarter of 2020 that have been reused and reused and reused in 10-Qs over and over that aren't really current. So they're talking a lot about, you know, getting personal protective equipment and cleaning and government shutdowns. And while those things may or may not still be important or be affecting your revenue or be a real threat, that's not top of the list, you know, as Scott mentioned earlier. And so really sitting down and talking about, you know, what have been the specific effects of COVID on our revenue, on our business, on our strategy, I think will be important for MD&A in this season.
Yeah, one thing that developed related to COVID, for example, are the vaccine mandates. And in some places, the vaccine mandates have caused people not to be able to come to work, or they've caused litigation challenges to the mandates. I was talking to somebody in the healthcare space that said told me on any given day, they have about 10% of their healthcare staff out, either because of COVID or because of the vaccination requirement, and so they're not coming in. So the big sick out that has made the headlines again the last couple of weeks as Omicron has spread, you know, those are sort of newer because those are actual things in the workforce as opposed to the government telling you to stay home. Mm-hmm. Anything you wish to add on that?
No, I think those are important ones, and you touched on it a little bit, but I think the 4 part of MD&A really, you know, much of your 34 Act reports focus on historical disclosure, but that's really an opportunity, and there's an expectation to discuss what the trends are kind of on a go-forward basis as well. I don't think we're talking about including financial projections or anything like that, but discussing where you think not only where you've come, but where you think it's headed, what the key drivers are. If you foresee, operating expenses going up because labor is more expensive, if you see, supply chain issues requiring you to find alternative sources for items in your supply chain, and that's going to make it more expensive. If shipping delays are, costing you, I think those are things that you need to talk about, not just historically, but also give a sense for where that stuff is headed. And I think it's important to remember that.
Yes, yeah, some companies that are in the supply chain are finding that their clients are not happy with the delays, and they're wanting them to pursue alternative delivery routes, bringing product in through the East Coast instead of the West, bringing it in through Mexico, through the southern border. I'm assuming legally, but then there are costs, and we all know shipping costs have gone up enormously. Things that were costing $2,000 to ship in a container a year ago were costing $15,000, $17,000, $20,000 for the same container, and we're seeing the customer pushing back on the supplier to ask the supplier to bear more of those costs, and those are the kinds of things that ought to be assessed for inclusion in MD&A. Well, let's go on again. Just take a fresh look at some of those things, and ask yourself, if people read only the first 4 paragraphs of our MD&A before we get to our period-to-period comparison, do they have a pretty good picture of the high-level issues that are driving us or concerning us? I think that's one way to approach that.
All right. Moving on from Reg SK over to the exchanges. So voting standards are very interesting to me, and I appreciate that they're a very nerdy thing to be interested in, but hang with me for a minute. So when you think about the votes cast standard under Delaware law, what that really means is for any proposal, there need to be more yeses than nos, and abstentions are not counted as votes cast. So you're really only looking at yeses versus nos. The NYSE has historically, for NYSE required votes, so that'd be the 20% rule, that'd be equity comp plans, they have held a definition of votes cast that has included abstentions as nos. So there have to be more yeses than nos plus abstentions. Really, this was just a hassle for some companies who maybe had a regular Delaware votes cast standard in their bylaws, but had to apply a heightened NYSE votes cast standard for NYSE votes. And that's been eliminated. The NYSE now defers to companies' governing documents and applicable state law in applying the votes cast standard. So if this applies to you in your upcoming proxy statement, do make sure you look at your disclosure surrounding the required vote for any given proposal, and that you're describing it correctly given the rule change.
I'll just note that we have seen some plaintiff activity where either the votes standard was incorrectly described or the effect of broker non-votes, and whether something in fact was discretionary or not discretionary was not accurately described in a proxy. And even though the votes were counted correctly under the rules, the plaintiffs do send letters saying that the vote should be invalid, and seek improved controls over disclosures, and of course they want their attorney's fees. So it's just worth double checking. The lesson we used to say was, if you're an NYSE company, don't plagiarize the vote standard from a NASDAQ company or vice versa, even if you're in the same jurisdiction. But the good news on that one is that ought to go away. Now just plagiarize from the ones that get it right.
Yeah. Alrighty. Sticking with NYSE, last year there was an amendment. The NYSE amended its listed company manual to require listed companies to have their audit committee or another independent body of the board to conduct a reasonable prior review and oversight of all related party transactions for potential conflicts of interest, and to prohibit the company from engaging in those transactions if they determine that the transaction's inconsistent with the interests of the company. This was important for a couple of reasons. Number one is, you'll see it bolded on the slide, the requirement for prior review. We'll touch on this a little bit more later on this slide, but that was a sort of a new thing. Many of you probably have policies that address approval of related party transactions by either your audit committee or some independent body, but many of them include the ability to ratify those after the fact rather than prior approval. And so when this rule was adopted, there were a lot of folks who said, well, now do I need to get everything previously approved rather than ratify? And I'll circle back to that in a moment. Another thing that a lot of folks were concerned about was that the NYSE rule, as initially amended, it referred to the item, the Reg SK requirement for disclosing related party transactions to determine which transactions required approval under the NYSE, but it did not include or did not apply the transaction threshold of $120,000. So you could have a transaction for $1 under the initially approved rules in April of last year that would require the prior approval of your audit committee to pursue. Later, there was much made of this rule change, and later on in the year, the NYSE did amend it to make clear, or to conform rather, the requirement to the SEC, or the Reg SK requirement, and to add in the $120,000 threshold. So now it is in line with most people's, or at least with the disclosure requirements, and with many people's policies. There's still the issue of the prior approval. The SEC still allows companies to have policies that permit the ratification of related party transactions, and also requires them to disclose when they, do something that is not consistent with the policy, if they proceed not consistent with the policy. So each company, we think, needs to consider whether the new NYSE standard and the reasonableness requirement specifically, it requires you to conduct a reasonable prior review and oversight, whether that allows any room for complying with policies that allow for ratification after the fact. So this is something that we have a lot of clients who are asking for input on, and seeing how it affects them, and what, if any, changes to their existing policies are necessary. So if you haven't already done this, it's worth taking a look at your policy, seeing how it how it compares to the new NYSE rule. And of course, we're happy to help you think through those as well.
But failure to conduct a reasonable prior review is not a violation of SEC rules.
Correct.
It may be a violation of your listing requirements.
Exactly. That's
That's kind of where we are.
Yep. So now we're going to move to some new rulemaking and some expected rulemaking. The next few slides are sort of summaries of a number of things that we're going to touch on later. So I'll try to breeze through these relatively quickly. First, filing fee modernization. The SEC adopted amendments to make it a little more clear how you disclose your calculation of fees. Now there's going to be an exhibit that you're going to include the fee calculation in. They also are allowing you to pay your filing fee for the filings that require a fee via ACH or debit or credit card. So it should make it easier for many folks to pay it instead of having to wire funds to the SEC. The next two, I think, will be important to many of our clients. We've had a lot of clients reach out on both of these points. I'll touch them only very highly here, and then we'll get to them later in the deck. But first, the SEC is proposing rule changes regarding disclosures of 10b5 plans. These are sort of non-discretionary repurchase plan or plans to buy or sell shares that are non-discretionary and could potentially be done during an otherwise closed window, or when you otherwise have MMPI. Under certain circumstances, 10b5-1 provides an affirmative defense against claims of insider trading. The proposed rules would require the issuer to disclose in their annual reports whether they have an insider trading policy, and to disclose what those procedures are, and also to include in their reports the adoption or termination of 10b5-1 trading plans by their directors, officers, and the company itself, and the terms of those arrangements. So many companies, particularly in the last year or two, have been utilizing share repurchases. And many of them are also doing it under 10b5-1 plans. So you're going to want to definitely pay attention to who at your company, directors and officers, have those plans, and also whether the company itself has it. As I mentioned, share repurchases, transitioning to that one, just briefly on the last slide, there are additional rule changes regarding share repurchases that would require potentially the filing of this new Form SR that would be due the day after you execute a repurchase. So in addition to disclosing potentially 10b5-1 repurchase plans, you could also have to report your actual repurchases as they are executed. And again, we'll touch on those more later on.
Yeah, because after all, material information on 8K should be reported 4 business days later, but share repurchases that have previously been announced are more important and should be reported 1 business day later.
Exactly. Yeah, you've got it, Robert.
Yeah, okay. I think so.
Continuing on, again, I'll hit these at a very high level because we're going to touch on these later in the deck. But you would likely have seen in 2021 the SEC coming out announcing that it was going to focus on cybersecurity disclosures, and they did bring a series of enforcement actions against companies for inadequate cybersecurity controls and disclosures. We were expecting there to be rulemaking in this area at the end of last year. It did not come, but we are expecting it to happen at some point this year. Rule 144, again, we'll touch on this in more detail later, but there are proposed changes to Rule 144, which would require the electronic filing of Form 144, which currently many folks are filed by affiliates. Currently, most folks are filing those in paper form. So this would be a big change for those who have folks who are selling under Rule 144.
Yeah, let's just talk about that, sure, and we'll skip the later slide.
Sure.
So most of you don't deal with market adjustable securities, which was the main topic of that release. This is a release that came out at the end of the Trump administration. It's not been adopted. It has one thing that's a little harder, but not really much on insiders, which is the electronic filing of Form 144. Anyone who's looked for a Form 144 knows that hardly anyone files electronically. There's a bunch more that send it in by email, and then the rest are all in paper and next to impossible to find.
Something like 99%.
Yeah, 99% of those are that way. So they're just all pushing it electronic filing. But in the same release, they said they're not due until 2 business days after. So they used the Section 16 deadline to also be the deadline for Form 144. And as we all know, if there's anything that gets messed up on a Rule 144 transaction, it's that the broker doesn't file it the same day as the sell order or the execution of the trade, whichever's earlier. And so this is actually good if it were to be adopted. That's why I doubt it will be. Okay, so that's 144. It may or may not happen.
Yep. Continuing on, Dodd-Frank this is with regard to clawback. We'll touch on this a little bit later as well. But the SEC proposed some rules back in 2015 that were never adopted. They reopened the comment period last year on those, and we're expecting them to announce some final rules coming this year.
And that'll be on the next panel.
Yes, that'll be on the next panel, so stick around for that. And then lastly on this slide, which Robert will cover in a little while, the SEC adopted rules requiring this is particularly for our oil and gas and minerals companies, requiring resource extraction issuers to disclose payments made to U.S. federal and foreign governments for commercial development of oil, natural gas, and minerals. This first filings are going to be required in 2024 to disclose payments made in 2023. So for all of you oil and gas and minerals companies, be sure to keep that on your radars. Next slide. Proxy voting advice. The SEC is re-examining some of the rules and guidance they previously issued in this regard. They proposed amendments at the end of last year that would rescind a large portion of the previously issued guidance. The comment period just ended at the end of last year, so we'll see where that shakes out this year. With regard to human capital resources.
I have a prediction.
Is that right?
They're not enforcing the rules, and they're going to overrule them. They're going to reverse what they did, pretty much in line with their proposal.
Yep.
That'll be discussed in a later presentation.
Yep. Quickly, with regard to human capital resources, Chair Gensler suggested that new requirements would include a series of metrics and then asked the SEC to propose recommendations for what those rules would look like in line with what his suggestions were. So we expect those to be forthcoming. And then it'll be a topic that'll be touched on significantly in a later panel. But climate change disclosure, Chair Gensler, or the SEC, was expected to propose mandatory climate change disclosures at the end of last year. Those regulations were not released. What we did see was a sample comment letter from the SEC about climate change disclosures, and we'll see how closely the ultimate rules mirror those comment letters.
Okay, so 10b5-1 plans. get a lot of attention. They're very, very useful for any insider of the company if they want to put it in place when they do not have material non-public information that would allow them to trade through periods in which they may be in possession or in fact are in possession of material non-public information. But just a reminder that we went 70 years almost under the securities laws without the affirmative defense provided by Rule 10b5-1, because you always could, if you did not trade while in possession of material non-public information, the plaintiff had the burden of proving you did in order to bring a case, and same with the enforcement bodies. So it's not the end of the world if this gets modified or eliminated, and they're not proposing eliminating it, but it will change some practices. In some cases, I'm not wholly convinced for the better, but that's a different issue. The two main things is they're talking, well, there's a few main things, but they're talking about having executive officers and directors have a mandatory 120-day cooling off period between the date they enter the plan and the date it first executes a transaction, and a 30-day cooling period for issuers. So it's shorter for issuers. The nice thing is in the adopting release, the SEC confirmed that there is not a cooling off requirement under the current rules. For all the commentary out there about whether that's good practice or not, the reality is you can enter a 10b5-1 plan on a day when you have no material non-public information, and it can start executing immediately. Why? Because you have no material non-public information. Having a cooling off period doesn't change that. They're not proposing to change the rule to say, well, you can adopt it if you have material non-public information, so long as that information is released to the public before the 120 days or before the 30 days. That's not the rule. The rule will still be proposed, as proposed is, you can only enter it when you do not have material non-public information. So all of the rest of this is window dressing, either because people think it's been abused somehow, or they just don't think insiders in the company should be able to transact in plans very well, and it will affect that. They want to add a certification that the officer or director is not in possession of material non-public information, and they're talking about whether the company should be obligated to get that certification and retain it for 10 years, 7 years beyond the statute of limitations. Okay? They don't like multiple overlapping 10b5-1 plans. They've indicated in the release that that may be an abusive practice, even though in some cases, in many cases, all you're doing is things you could have layered in the same plan. And they haven't addressed that in their proposal. And then they really don't like these single trade plans, and they want to limit that to once a year, and then they're keeping the good faith requirement. The thing I want to call your attention to on this disclosure is that they not only want you to have to disclose in your quarterly reports the adoption and termination of 10b5-1 trading arrangements, but they also want you to disclose other trading arrangements. So even if it's not a 10b5-1 plan, but you've got a limit plan or whatever that an officer or director enters into, they want that disclosed. And that creates information gathering and disclosure issues, and is any of this material? And these are things we ought to be commenting on. They do want to accelerate gift reporting to make it mandatory in 2 business days instead of voluntary, because they've somehow suggested that that will allow better monitoring of illegal insider trading. I don't know how, because Form 5 is filed within the statute of limitations. But that's some stuff. And then the big thing, which we mentioned earlier, is that your insider trading policy is going to have to be summarized. By the way, the proposing rule did not say that you had to disclose the pricing terms, but it does say terms. And so we're going to end up in a debate about just how much disclosure goes in of these plans unless we can get clarification. We are really at the end of our time here. So these are the proposals. Share repurchase reporting, we've said next business day. If you're a resource extraction issuer, this is a reminder that at the start of next year, you have to be compiling the data to be able to do your report that will be due on a Form SD for you and your subsidiaries and your controlled entities. And the good news is that the controlled entities are using an accounting control definition and not the securities definition. But that's going to be due September 30th, 2024 for 2023, which means January 1st, you're collecting that data for the full year, which means this year you should be testing your systems to do that data and collect that report. And if you don't have that going, now's the time to get that thing ramped up. We've skipped Rule 144. We've told you that there are better ways to pay coming into effect. And please, please, if you want to get comments from the SEC, be sloppy about cybersecurity disclosures, especially when you've already had an incident. Don't bother to put in reporting up obligations within your company so that your management never knows when there's a significant incident and they fail to report it. That's a good way to get into trouble from an enforcement perspective and a comment perspective. And continue to ignore GAAP first, GAAP more prominent, GAAP reconciliations, explain the reasons for non-GAAP measures. Those are the key things in the comment letters, and we've given you detail there. Let's take a 5-minute break and we'll resume with our next panel. Okay, we're going to go ahead and get started. We'll be joined in a moment by our colleague Dario Mendoza. Again, I'm Robert Kimball. To my right is Catherine Frank, and to my left is Scott Rubinski. All of us are partners in the capital markets and merger and acquisition group. Dario Mendoza is in our employee benefits and tax group. So he will be on here in a second. Okay. So going back to slide 9, one of our sharp-eyed viewers noted that the legend sample in there is the old legend sample referring to competitive harm and not the current legend that just refers to confidentiality. And so we will fix that and recirculate. And our sharp-eyed viewer, if you did not provide your contact information to our chat moderator, would you please do so that we can get you a good sizable Uber Eats voucher or a choice of Viennese Bling of your selection. So we do appreciate those eyes on there. Thank you. We are now going to shift to talk about annual meetings, shareholder proposals, and proxy advice. Dario, welcome. And I believe, Catherine, are you starting us off again?
Yes, I am. With the question of the hour, which is, should we do a virtual meeting this year, or are your other clients holding their meetings in person? And I think the answer is virtual meetings are here to stay, as evidenced by this Zoom CLE instead of having you in our offices today. The uncertainty with new variants, and then the popularity of virtual meetings over the past few years have really shown that I think the shift may be permanent. One of the things that people have really liked is that there's time and cost savings, of course, but even those who protested against them in the first place, some of the, shall we say, gadfly shareholder proponents have enjoyed showing up at meetings when they're presenting and saying what they'd like to say in person instead of sending a proxy to speak for them. So just a reminder, if you are sticking with a virtual meeting, that you need to be clear on logistics, you need to be clear in your proxy statement about tech support, how to join. Glass Lewis actually has laid out exactly the disclosure they expect to see with respect to virtual meetings, and they will, in some cases, recommend a no vote against your NomGov committee chair if they don't see that disclosure. So this tick list here on slide 47 ticks through Glass Lewis's expectations for proxy disclosure should you hold a virtual annual meeting.
You think when Delaware first was clear about allowing these things, and and as some people experimented with them, there were some of the notable activists were arguing that this was a way of insulating management from the shareholders, and it would be harder for them to participate. There still have been criticisms about whether there's too much editing of the questions that come in and whether they're really addressing the questions that are being presented. And that, I think, is a really fair one. But I think, first of all, COVID has just, as Catherine said, made this a more acceptable practice. And second, by having so many companies do this, we have seen, in many cases, greater participation because of the lack of the travel costs. And I'm going to pick on Mr. John Chevedden, who is one of the well-known gadflies, and he used to go and hire temporary help from some staffing agency to go read his proposal and present it at the meeting. And sometimes they did fine, and sometimes they were scared to death and messed up, and then he would be convinced that there was a worldwide conspiracy against him to prevent him from presenting things. But what I've noticed is he has been on the phone himself at these virtual meetings much more than we ever saw him in person at meetings. And he's been handling this. So it's been a great cost savings to him. He doesn't have to pay minimum wage to undertrained people to go present for him. And he can say what he says. And of course, he wanders off script from time to time more freely than these paid people would. So frankly, I don't know why they would really think that this hasn't overall been an increase in participation, other than the question of whether the questions are somewhat transparent to the other participants in the meeting and are being addressed. So I think they're going to be around for a long, long, long time, myself, and but we hope always without the dogs barking in the background.
Okay. All right. Next slide. There we go. So last year, the SEC approved amendments to the proxy rules mandating the use of universal proxy cards in solicitations involving contested elections after these contexts after August of this year. So the bold language on the slide is the key one. Proxy cards distributed for contested elections will have to include both the director nominees and allow both sides director nominees and allow shareholders casting their votes to mix and match nominees. So this is something that activists have sought for a long time. And so finally they have it.
It's their holy grail, right?
It is.
This was the holy grail. There
There
are articles out there calling this the holy grail of shareholder activism.
They'll surely have no other proposals that they'll need from now on, right?
Done. They've gotten there. There is no more to ask from us.
I think that's right.
It's over.
Yeah, I think that's right. Well, we won't even touch this topic next year, I think.
Yeah, that's right. So what's next? Mandatory inclusion of the activists' material in the proxy statement itself? Is that what they're going to go after next?
I guess only time will tell. But the universal proxy, likely it's going to result in potentially more contested elections and also make it easier for activists to kind of run contested elections. So that's what they were seeking and they got it. So we'll see how this plays out.
Yeah, what it really facilitates is the ability to pick and choose among directors instead of saying, well, I'm management slate or I'm on the activists' full slate or short slate. It really kind of is going to let them go in one by one, all on the same ballot, and do that. So, but anyway, it is the holy grail. It's there.
Yep.
All right. Moving into shareholder proposal trends. Now, all of you year-end filers have probably already passed the deadline for 14A proposals this year. So this analysis is of 2020, 2021, because we haven't seen all the 2022 proxies out yet. But I did want to highlight some of the trends we're seeing because anecdotally they are holding for 2022. You'll note that governance proposals are consistently top of the list and they go through trends. Most recently, it's been written consent proposals, but we're still seeing a lot of shareholder special meeting rights proposals. Or elimination of supermajority provisions. Those continue to be common and have been common for the past 2 years. Additionally, we've seen a major increase in social proposals, and this is a really large subcategory, or a large category, and it has a lot of issues, but the largest subcategory of social have been anti-discrimination and diversity-related proposals. It'll be interesting to see this year, since board diversity is now required to be disclosed by NASDAQ-listed issuers, whether we will see as many of these proposals this year. Environmental proposals also on the rise, anecdotally continue to be on the rise this year. Maggie's going to speak a bit on these in her E portion of the ESG panel, so I won't steal her thunder, but climate change, of course, being top of the list in terms of environmental proposals that are coming in. Civic engagement has held steady for the past few years, and executive compensation proposals have actually gone down over 2020 and 2021.
So we saw a lot of effort over the prior couple of years, 2019, 2020, to moderate the influence of the proxy advisory firms, ISS, Glass Lewis, and their like, as well as to try to facilitate some elimination, duplicate representation of duplicate proposals or multiple proposals from the same proponent. And very quickly, the SEC staff turned around on this past year and has undercut a lot of those changes, pushing them back to where they were, or some cases even more favorable to proponents. So when you look at, we've got a lot of detail here for the 14A geeks, but the truth is, if you're a real 14A geek, you've already read these changes and you know them better than our summary. So this is for the intermediate level geeks, I think. But the short version is it's just going to be a lot harder to exclude proposals. On procedural bases, you probably have to go back at them at least twice on their problems. And they're suggesting that proof of ownership standards are too tight, although why asking a broker to say, yes, these people really have an account is too hard a standard is beyond me. It was set in case law originally. So these are in the aggregate a series of changes that essentially mean that companies are going to have to deal with more of these. The big issue we're all waiting on to see is we saw what we think are really multiple proposals from a single proponent, but they've recharacterized the letter from the second shareholder to really just say, this is my proposal, but you've got to talk to the other guy about it who's already put in their own proposal. And that just seems like a transparent sham, but whether the SEC, the current SEC, will see it that way, I think is still anybody's guess. There's a lot of companies waiting to see what the staff's going to do on that. So we've given you some options on how to respond, but I think that's really reading material as opposed to talking material here. We're happy to talk about very specific requests that you've got in.
Yeah, and along those same lines as reading material, we've also included several slides. As many of you likely know, the big proxy advisory firms, ISS and Glass Lewis, as well as some large institutional shareholders like BlackRock, they publish annually, they update their sort of shareholder guidelines, and it indicates every year sort of how they will recommend votes for or against particular proposals, or for or against individual directors, chairs of nominating governance committees, comp committees, et cetera, for a variety of reasons. So we've included a summary of the ISS, Glass Lewis, and BlackRock updates. You can take a look at them at your leisure. The highlights would just be many of them are addressing, disclosure around diversity and diversity in board composition. So that's something that we knew was coming our way, and the advisory firms are making that point very clearly. They've also included, some updates around, climate disclosure and whether, in the case of BlackRock, whether they would be supportive of shareholder proposals made by others in that arena. So you can take a look at those on your own, and of course, let us know if you have questions on those.
Probably in that we should mention an increased hostility to classified boards of dual class voting shares, and a signaling of a greater willingness to go after board leadership on those points, if even in an IPO company, if those haven't gone away after about 7 years, or if they didn't have an automatic sunset provision. So, that's doesn't mean that IPO companies will change their practice on that, which is to have defensive measures, but it does mean that somewhere around as soon as they have a meaningful institutional base, they're going to have pressure to put a sunset provision in there. Is that, I think, Dario, if we can turn time over to you.
Yeah, that's me. Thanks, Robert. So I'm going to cover a few compensation-related updates. Let's kick it off with ISS. Last month, they published some updated FAQs related to pandemic-related pay adjustments. Some of you may be aware that similar FAQs were originally published in October 2020. Generally, the FAQs serve as guidance on how ISS may approach pandemic-related pay decisions for this, upcoming proxy season. Despite, kind of still being in the midst of the pandemic, ISS really expects to see a return to traditional or pre-pandemic compensation structures. They specifically mentioned the fact that, unfortunately, we're still in the third year of the pandemic. We're in the second kind of disclosure season, that's focused on pandemic-related actions. And so ISS feels that the surprise nature of the pandemic is no longer applicable. So you can't really use that as an excuse anymore. So beginning this year, this proxy season, ISS will generally react negatively to the following, and, subject to this caveat, and this is a pretty big one, unless robust disclosure and clear rationale is provided justifying these actions. So I expect that some of the people on this call, if not most of the people on this call, their company probably implemented one of these actions. And so I just want to, reassure you that that is fine. Like, that is, ISS almost expects that. They know that adjusting to the pandemic, changing pay programs was kind of necessary. But, they will react negatively to these things unless you provide clear disclosure explaining why you did it. And we'll go into what that clear disclosure should look like on the next slide. But let's first cover these sort of actions that ISS may look at negatively. So first, mid-year changes to incentive program metrics, performance targets, or measurement periods. So here, ISS is focused on short-term incentive bonuses, annual bonuses. They really don't like you changing metrics, targets, or sort of shortening the performance period mid-year. ISS would prefer to see how things play out, and take that into account if you are planning, or if you did, make any adjustments to your annual or short-term incentive bonuses. They also dislike incentive programs that heavily emphasize discretionary or subjective criteria. ISS definitely prefers pay for performance. They want to see a strong link between performance and pay. And so just basing annual bonuses or short-term incentives on discretionary criteria, whether it's board discretion or committee discretion, that's really kind of disfavored by them. The next bullet, changes to in-progress long-term incentive awards, really the same as the preceding bullet, except focused more on long-term equity awards like performance shares, performance share units. ISS really wants to see you kind of let those play out rather than modifying, despite, kind of the effects of what the pandemic could have been on those awards. Third bullet, a shift to long-term incentive awards with predominantly time-based vesting or short-term measurement periods on a go-forward basis. Again, ISS really does prefer to see a strong link between performance and pay, and so shifting to a structure that kind of minimizes the performance-based element, shifts to more of a time-based structure, or even a performance period that's short, say 6 months or a year. They want to see that be 3 years ideally or longer. And then finally, one-time special awards, unless they're reasonable in magnitude and an isolated practice. So I think a lot of companies with the pandemic, PSUs have maybe paid out below target or have had some issues, same with incentive compensation. And so a lot of companies have turned to paying these one-time special awards. ISS understands that, but they should be reasonable and isolated. I think a lot of the disclosure last year that ISS saw focused on retention concerns as kind of a boilerplate reason for granting those awards. And ISS has basically said this year, look, that's not going to fly. We need some more detail than that. So even if retention was, sort of a driving consideration in granting those awards, ISS thinks you should have, a different rationale or an additional rationale for granting those. And then finally, repeated use of one-time awards in consecutive years is also problematic, as is the grant of one-time awards to replace forfeited performance awards. And so we talked about this a little bit earlier with modifying performance awards. ISS really doesn't want to see you either modifying performance awards to make them easier or granting new awards to replace foregone performance awards. And so let's take it to the next slide, please. Okay. So I mentioned on the preceding slide that, look, I'm sure many of you have taken some of those actions during 2021, and you may take them again in 2022. That's not the end of the world. ISS recognizes that companies are taking these actions. It's a result of the pandemic. So to the extent you have taken any of those, this slide really focuses on what sort of disclosure you should be providing in your proxy, in your 10K, your CD&A, to kind of address those actions that were taken. So if you made any mid-year adjustments to your incentive programs, ISS wants to see disclosure on why you felt those actions were necessary. The disclosure should focus on any specific pandemic-related challenges you faced and how those challenges rendered the original program design obsolete, or maybe the performance targets were simply impossible to hit and executives would have made nothing on those awards. In addition, how changes are not reflective of management performance. I think what ISS is getting at there is they really don't want the tail wagging the dog. They don't want you to look at the compensation that executives are going to get as compared to what they've got in years prior, and really kind of reverse engineering the awards to where you pay them kind of what they have traditionally gotten. Instead, you should be focusing on, okay, if these metrics didn't work due to the pandemic, due to changes in our business, changes in whether we've had stores open or things like that, you should be redesigning the metrics kind of based on that, rather than executives going to get 40% less comp this year, so we need to fix that. In addition, ISS does understand that with the pandemic, companies may have shifted performance targets downward. They may have shifted to some more subjective factors, as part of the overall criteria. They view that as reasonable if you continue to incur severe economic impacts and uncertainties as a result of the pandemic. Companies who did, take those sort of actions should clearly explain the targets they set, any changes they made, and really explain that rationale to investors. As far as alterations to go forward equity grant practices, changes to that could also be viewed as reasonable. One example that ISS gave was, a lot of companies like to split their equity awards between time-based and performance-based vesting. And ISS obviously prefers to have, more weighting on the performance side. If you, predominantly granted performance-based awards in the past, ISS is okay if you want to shift that a little bit more towards the center and grant, more time-based awards. So a modest change, along those lines is completely fine with them. Finally, if you do grant one-time awards, they feel that those awards should be strongly performance-based and ideally long-term. So we're talking, multi-year performance periods. And in addition, those awards should contain shareholder-friendly features that avoid windfall scenarios. The example that ISS gave was limitations on termination-related vesting. What they don't want to see happen is an executive who is entitled to walk away, maybe voluntarily retire, and still get paid out on those one-time awards. And instead, those awards should only be paid out if the performance metrics are achieved, or if the executive were to be terminated without cause, or maybe a constructive termination for good reason. Next slide. Okay, in addition, ISS also updated the equity plan scorecard. Some of you may be familiar with that. That is the model by which ISS evaluates equity plan proposals. And so that would be if you're adopting a new equity incentive plan, or if you're amending an existing incentive plan to perhaps add more shares or make some other change that needs shareholder approval. ISS will evaluate your plan based on a few different factors that include the features in the plan, whether there's liberal change of control vesting or single trigger acceleration, in addition to just kind of plan cost metrics. And one of those metrics is burn rate. And so ISS has traditionally looked at a 3-year burn rate as compared to your peers, as compared to your industries, as one of the components on the equity plan scorecard. That methodology that they've used, the calculation for burn rate, has been what's called a volatility-based burn rate. They are changing that beginning in 2023 to a value-adjusted burn rate. And what that means is they've changed kind of the calculation for options and stock appreciation rights to use a Black-Scholes formula. And they've also changed the full value award calculation, which really means restricted stock or RSUs or phantom awards that settle in shares, to a stock price methodology. So this will result in a change to the sort of burn rate that's typically calculated. ISS views this as more accurately measuring the value of equity awards. I think they're giving us a heads up, a year early, because they're going to put this new methodology through a trial run this proxy season. So if you are putting a plan up for shareholder approval, if you do get the equity plan scorecard report, you will see this new burn rate methodology displayed, but it will just be for informational purposes. It won't count in ISS's score of your plan proposal. And ISS noted that they'll provide more information on this methodology after this proxy season. Okay, so earlier when we touched on the new proposed Rule 10b-5, amendments, included within that was actually a change to Item 402. And as many of you may know, Item 402 is what governs the compensation disclosures that are provided in a proxy or a 10K. A new section, the SEC has proposed that a new section would be added to Item 402, Section X, and that would require tabular and narrative disclosure in a company's proxy or 10K for option awards granted to NEOs within 14 days before or after the filing of a periodic report on Form 10K or 10Q, an issuer share repurchase, the filing or furnishing of a current report on Form 8K that contains material non-public information, including earnings releases. So option awards means options, it means stars, it means similar instruments with option-like features. The table that the SEC wants to see in your filing would include info on each option award, the number of securities underlying the award, the date of grant, the grant date fair value, and the exercise price. In addition, they'd like to see the market price of the underlying securities on the trading day before and after disclosure of the material non-public information. The narrative disclosure, which the SEC would expect to see in the CD&A if you include one in your proxy statement or your 10K, or if you don't, and just sort of a stub table or a sub narrative to the table, that would include information on how the board and committee determines when to grant options and whether you take into account material non-public information when determining when to grant and the terms of the grants that you make. What's somewhat interesting about this proposal is, emerging growth companies and smaller reporting companies are subject to relaxed compensation disclosure rules. By way of example, they don't have to include a CD&A, they don't have to include all the tables, but under this proposal, those companies would not be exempt from this new disclosure requirement. These are only proposed rules for now. You won't have to include this sort of information until those rules are finalized. And I think most practitioners expect that the disclosure requirements may not be as robust as what the SEC has indicated here, or this may not even make it into the final rule. So just this is a sort of just FYI, stay tuned and see what ends up happening on this. Next slide. Okay, clawbacks. So we mentioned earlier that the SEC reopened, the comment period for the clawback rule. Let's just briefly, tick through what a clawback policy is. That allows companies to claw back or recoup compensation from employees upon the occurrence of a triggering event. Those triggering events are typically accounting issues, errors in financial performance measures or reporting, perhaps fraud or misconduct or a violation of company policy. Typically, clawback policies will focus just on incentive compensation. In some cases, it's broader and can focus on all compensation received by an executive or by a director. The group of individuals covered can vary from company to company or policy to policy. Some of the groups you'll see are all NEOs, all Section 16 officers, all directors, certain managers or employee groups, and then finally everybody at the organization, all employees and directors. As far as the amount recouped under the policy, that can vary as well. So in the case of an accounting issue or a financial restatement, that could just be the difference between what was actually paid out and what should have been paid out, had the error or mistake not happened. In the case of fraud or misconduct or a violation of policy, it could in some cases be all compensation paid, under that arrangement or any plan or program. Next slide. So let's go over some developments regarding clawback policies. So the SEC originally, the Dodd-Frank Act required the SEC to adopt rules regarding clawback policies. In 2015, the SEC adopted proposed rules, but that rule has never been finalized. However, institutional shareholders and proxy advisory firms like ISS and Glass Lewis have really been focused on clawbacks for the last few years. And so you'll see that, under this statistic, 92% of S&P 500 companies disclosed clawback policies by 2016. But without final rules from the SEC, these policies really range widely in how they're applied and the strength of them, what they claw back, who they apply to, et cetera. So where we stand right now is we still have proposed rules from the SEC that were set forth in 2015. In October 2021, the SEC reopened the comment period through November 2021 on those proposed rules. The SEC has made this a priority recently, so we're expecting that a final rule will be announced this spring, as soon as a few months from now. Once the SEC publishes that final rule, NASDAQ and NYSE will have a limited period of time, I believe it's 90 days, in which to adopt listing standards that require companies to implement clawbacks that are in line with the SEC rule. Once that happens, those listing standards would provide sort of a grace period or amount of time in which you have to get your clawback policies adopted or amend them if need be. And so, this is, even though this final rule may be coming soon, there likely will be a period of time, could be a few months, could be a year, in which you'll have time to kind of adjust your clawback policies or put new ones in place.
Great, thank you, Dario. We mentioned earlier already that the proxy voting advice is basically mostly being undone, so we're going to skip through that, and we're going to have a new panel to take us through to 11. And so we appreciate Dario joining us, and we will now connect in Maggie Peloso. Maggie is the lead of our sustainability practice. And there she is. So
morning.
Welcome. Good morning. Welcome, Maggie. So we have Margaret Peloso, Maggie, Catherine Frank, whom you've previously met, and Craig Zeminski, who's a partner in our complex commercial litigation group. And they're going to talk to us about some of the regulatory and other developments relating to environmental, social, and governance as a lead-in to the panel that Maggie will chair after a kind of a 5-minute break following this panel. And she'll introduce her guests on that discussion panel at that time. So turn that over to the panel. Thank you.
Thank you, Robert. So let's move forward 2 slides, please. I'm going to briefly review some of the developments in the climate space because, as Robert mentioned, we have a whole panel on ESG afterwards where we will dive into some of these issues more closely. I think the big thing to know about SEC developments in 2021 is that the Commission essentially decided to pull all of the levers at once. They had examination priorities around climate. They created a climate and ESG task force from the enforcement side. They revisited the 2010 climate change guidance to look at how they thought issuers were doing in complying with climate disclosures. And then they opened a comment period on climate change. Moving forward 1 slide, please. In the second half of the year, we saw the SEC continue with these efforts, including launching some investigations, and they issued the sample comment letter. Can we have the next slide, please? The sample comment letter, I think, is significant because this is based on the 2010 climate disclosure guidance. So this is essentially the SEC's views of what you ought to be disclosing right now, regardless of whether or not they make new rules for climate disclosure. So essentially, these are the things that they can put some pressure on quickly while the rulemaking process plays out. Can I have my next slide? So I think the biggest takeaway from this comment letter is number 1 on the slide. For many years, many of you and many other companies have been engaging in voluntary ESG disclosure. Those disclosures have become much more robust over time as shareholders and other activists have really leaned on companies to say, tell us a lot more about ESG. And that's really all happened in the voluntary space. And one of the trends we saw emerge next to that was a number of NGOs who were saying, hey, gosh, it's really interesting to us that you have so much to say about these issues, especially about climate, when you're writing your voluntary report, but you don't think that any of that is material and none of it is making it into your periodic reporting. And so I think it's notable that the SEC is thinking about that question now itself. I do think that that means that as you go into this season, it's important to be mindful about what that gap between your voluntary disclosures and your periodic reporting is, and what your response would be if you were to be asked, well, why are you disclosing this in one place and not the other? This is not to say that every climate or ESG risk rises to the level of materiality that needs to be included in reporting, but I think it's important to be prepared for those questions. Next slide, please. The next thing we're expecting is the climate disclosure rulemaking. We've already touched on this a little bit. We generally expected that this rule was going to come out last October before the climate meeting in Glasgow, which it obviously did not. And then there was a lot of noise based on this disclosure in the Unified Regulatory Agenda that it was going to come in December. Again, that did not happen. Currently, we are hearing that perhaps the rule will come out later this month or early next month. I think there is a lot of pressure for the SEC to get something out into the public space, but it seems that perhaps they're still grappling with what that something should be. In terms of what we know, in terms of what might go into that rule, I think we're all still just trying to read tea leaves. In a speech given over the summer, Chairman Gensler did say that he's asked the Commission to look into the reporting of Scope 1, Scope 2, and potentially Scope 3 greenhouse gas emissions in there. I should pause briefly and tell y'all what those are. Scope 1 are your direct emissions, so that's if you own a factory and you have a smokestack, it's what's coming out of that stack. If you own company vehicles and your employees drive them around, that would be in your Scope 1. Scope 2 is your emissions from your purchases of electricity, and Scope 3 is the emissions from everything else you consume. Scope 3 emissions are very hard to account for. The data is not great, and so it's rather significant that the Commission is thinking about whether to require their disclosure. We hear some chatter that perhaps they're going to adopt a model that looks like the voluntary disclosure model that many companies use under the Task Force for Climate-Related Financial Disclosures, but not a lot of good insight into where these disclosures might be required or exactly what they might look like. So the Commission was still really grappling when it was in the first, like, hey, tell us about climate disclosures period, with whether this is information that will go into periodic reporting or whether this is going to be something like, hey, you got to write a climate report and put it on your website. So a lot to be seen, and I think there will be some activity on this soon. Can I have my next slide? We've already talked a good bit about voting policies, so I will go through these quickly. For ISS, I think the most important thing to know is that they will vote against or withhold director votes if companies aren't taking what they define to be minimum steps on climate-related risks. ISS defines those minimum steps to be disclosure under the Task Force for Financial-Related Financial Disclosures and quote-unquote appropriate greenhouse gas reduction targets. Then my next slide. Glass Lewis has also upgraded their guidance on how they're going to vote with respect to environmental and social risk oversight, which they roll climate into. They are a bit less specific than ISS on this. And then can I have my next slide? And then BlackRock has issued a series of more robust policies. The thing I really want to note here is not to review BlackRock's policies, but also to say that this morning, while we were on this panel, State Street released their memo and their voting policies for this year. And I think what we're seeing there is a bit of a race to who can have sort of the most robust climate policies and increasing indications that major asset managers are going to vote against directors if they view that companies are not taking enough steps to address climate and environmental risks. And then can I have my next slide, please? So just briefly, we've seen a huge uptick in support for proposals over the last year. And one of the things that we've noticed as a trend with our clients is that when companies are getting these environmental shareholder proposals, traditionally they weren't something we worried so much about because they didn't get a lot of support. But now the discussions are very quickly moving towards, gosh, do we need to go ahead and agree to whatever they're asking for or try to negotiate this out? Or how do we think about what happens if we lose or these proposals get a lot of support, because we see that the ones that do go to vote are getting a lot more support than they traditionally have. And then can I have my last slide, please? And so just to give y'all a sense of the kinds of proposals that we are seeing, there are a lot of climate change proposals out there this year. There are proposals on methane emission reductions. There's a number of proposals that fall into this category of say on climate, which is essentially we want you to publish what your climate strategy is and let us as your shareholders vote on it. It is still early in the year. I suspect we'll see a lot more here. But with that, I will turn it over to Catherine to talk about social issues.
Thank you, Maggie. So in the social arena, there are two areas I really want to talk about. One is I want to go back and revisit human capital resources disclosure. And if y'all recall, we discussed this a bit in terms of the SK updates from a couple years ago. And we had our first round of human capital resources disclosure in the business section in the last round of 10Ks. This has been an area of heightened interest because of social justice movements, more vocal employees, due to the so-called the Great Resignation that we're living through now, and then of course the pandemic. So we started last year with the SEC adding this principles-based human capital resources disclosure in the business section, and then last summer, Chairman Gensler signaled that the SEC might consider additional line item human capital resources disclosure moving forward. So that might be things like turnover rates, skills and training, comp and benefits, workforce demographics, so not just board level, but your employee base, and health and safety. Luckily, a lot of this lined up with pretty common areas of human capital resources disclosure that we saw in 2021. The big difference is that most issuers were not giving any sort of quantitative metrics in their disclosure. The disclosure tended to be narrative in nature. There was a lot of discussion of workforce compensation without any compensation metrics. Instead, they would talk about, benefit plans or incentive plans, things like that in a more general fashion. The real takeaway here is that as you prepare for potentially some rulemaking in this arena, and you're looking back at your human capital resources disclosure from last year, it's probably time to start being forward thinking. Who is responsible for monitoring human capital resources within your organization? Is it the board? Are certain areas more appropriate for management oversight? If it is the board, which committee is going to step in and have oversight of these various issues, whether it's data collection, maybe that's audit. If it's retention, maybe that's your comp committee. Really sit down and decide and allocate, who is in charge of what, and start thinking about what metrics might be appropriate for your company to disclose in the future, and set those internal oversight and processes up. So if the rules come down the road in the next year or year and a half, you've got the structure in place to start reporting and reporting accurately. So that's, and I would also prepare for institutional investor input. They've shown continued interest in human capital resources disclosure, and we expect to hear more in their voting standards over the next couple years. Heading over on the diversity front and specifically hitting the NASDAQ rules. We skipped over this in the first presentation. It really is, it's been an area of increased interest. And in December 2020, the NASDAQ filed their proposal with the SEC to adopt new listing rules associated with board diversity. So they have a couple of elements. One part of it is that the NASDAQ has undertaken to give complimentary access to a board recruiting service to help their listed companies. But the real, meat of it and the disclosure requirement for this year is that NASDAQ listed companies are required to include a board matrix either by August 8th of 2022 or the filing date of the proxy statement for their 2022 annual meeting. And in reality, we're seeing all of our NASDAQ listed companies start thinking about dropping that into their proxy statements this year. Then going forward, after more than just disclosure, phasing in from 2023 to 2026, companies will have a comply or explain mandate where they either need to comply and show that they have at least 2 diverse members on the board, including one director who self-identifies as female and at least one director who self-identifies as an underrepresented minority or LGBTQ+, or explain why they do not have one. We expect that the NYSE will eventually adopt a similar rule, but the NASDAQ rule is establishing itself as the new baseline for disclosure. So that you have it, this is what that matrix is required to look like. Of importance, they want this format. You may not delete a column. You may not come up with your own demographic background categories and add them in. You must include an as of date. They've put in a lot of FAQs on this and have been very clear that this is their preferred format, and that if you want to include additional information, and that includes information by director, so individually identifying the gender identity or demographic background by director instead of giving it in the aggregate, that would be considered supplemental. So it belongs in supplemental charts or graphics. They are very committed to this specific matrix. Historically, we've recommended kind of 2 approaches to diversity matrices and have suggested either the identify per director approach or identify in the aggregate approach. That's approach 2 up here. But again, want to flag for you that if you are a NASDAQ issuer, you are going to be going with the NASDAQ matrix and then be giving your additional information supplementally. And with that, I'm going to pass this over to Craig.
Thanks, Catherine. I'm Craig Zeminski. I'm a partner in the litigation group, as Robert said, and going to talk a little bit today about the board's duty of oversight under Delaware law, where part of a director's common law fiduciary duty of loyalty is the requirement to make a good faith effort to oversee the company's operations. And this is known as the Caremark Doctrine. So if we could go to the first slide here, we'll see that the Caremark Doctrine has officially become a cliche in Chancery Court opinions, where the opinions are recognizing, as they do in every single one of these opinions, that the failure to satisfy your oversight duties under Caremark is the most difficult claim for a plaintiff to prevail on. So historically, not a high standard, most cases dismissed at the pleading stage. we're starting to see a change in that trend of dismissal rates, and that's why we're going to talk about the evolving landscape today. So there's two prongs to the Caremark duty. As you can see here, the classic articulation down at the bottom, and they really go at this sort of yin and yang effect, where the board has to make a good faith effort to implement an oversight system and then to monitor that system. So prong one, you can see, again, a very low standard in this classic articulation. The board completely fail to implement any reporting information system or controls. And we see in other cases, it refers to, did the board utterly fail to attempt to put in place a system that passes the sniff test? Prong two then is, now you've put that system in place, are you consciously failing to monitor it? So it's effectively a recklessness standard. And you see the case I'll talk a lot about red flags. Was the board aware of red flags, of serious systemic problems with the company's important risks, and consciously ignored those red flags? So like I said, not a high bar here. You can see some of the case law on both prongs one and prong two. Under prong one, courts have emphasized it's not an invitation to nitpick or second guess the adequacy of the reporting system. A board isn't expected to have detailed technical knowledge. That's why you have operations experts in your organizations. They're the ones who have that detailed knowledge. The board isn't expected to be able to sift through all of that. Under prong two, courts recognize that even a perfect reporting system, especially a board level oversight system, isn't going to stop all illegal activity from happening in every nook and cranny of the company. It makes clear that red flags are serious irregularities that the board has clear notice of, and that a conscious disregard means that you knew about it and you did nothing. So that's kind of the classic articulation of Caremark and what we see in much of the case law. However, as you can see in the bottom of this slide, we're starting to see some perhaps different glosses on it in the case law. The Marchand Delaware Supreme Court opinion in 2019 emphasized that the oversight system has to be a reasonable one. And then Boeing, a couple months ago, interpreted the Marchand decision as imposing a rigorous oversight obligation when it comes to a company's key risks. So, this seems contrary to the classic articulation of Caremark that we see in the prongs. Now, Caremark and other pre-Marchand cases certainly did use this reasonableness language, though I think you'd be hard-pressed to find any case law that called the Caremark standard rigorous prior to a couple months ago. Remember that cliche we just looked at a minute ago. So, law school professors can debate whether we're changing the standard, whether we've rewritten the standard, whether it's just a different gloss on the same standard as always. But that's for the law school professors. We're practitioners here. And the bottom line is that more Caremark cases are getting past dismissal in the past few years. So we ought to make sure that our boards are matching this evolving landscape. And to do that, I want to quickly walk through the Marchand and Boeing decisions. And I think you'll see some patterns emerging. Marchand was about a listeria outbreak at the Bluebell Ice Cream Company. And you'll see here that what was important to the court, what allowed the complaint of a Caremark claim to get past dismissal, was that there was no board committee on food safety. There was no regular process or schedule for food safety. Management had bad info that didn't make its way to the board, and the management instead gave the board rosy information or overly optimistic information. Moving forward to Boeing, decided a few months ago, you'll see many of the same factors important to the court's decision there. These are quotes just taken from the subheadings of the court's decision as to why it was sustaining a Caremark claim in that case. So right off the bat, you see no committee, much like in the Bluebell case. And here in Boeing, the court noted, hey, you've got an audit committee, and that talks about oversight of risk in general, but that's not the same as having a board or a committee of the board that's looking at your operational risks, things like plane crashes or listeria outbreaks at your food processing facilities. So the case law doesn't say that it's mandatory to have a committee. I'm not suggesting that we all run out and create an operations committee of the board today. However, we've now seen two recent cases that have flagged the lack of an operations safety or risk safety committee as allowing a Caremark claim to pass the dismissal stage. Then we have the same thing we saw in Marchand, where there was no regular process, no regularly scheduled update each quarter on risk management, no regularly provided statistics, things of that nature. And in fact, just in the Boeing case, airplane safety, the court found based on the allegations, wasn't a regular agenda item or topic at board meetings. So we might consider, if we're digesting this opinion, making sure that our quarterly board packets have some statistics of our risk performance at an operational level that would allow the board to see trends, maybe ask questions, and to digest the information in a manner that a board of directors is able to, with further explanation and details of material incidents. And then going beyond just the financial impact, right? We want to actually dig into what was the root cause of whatever incident has occurred and what are we doing to resolve it, keep it from happening in the future, as opposed to just how much is this going to cost the company. Now, of course, technical knowledge can make this tricky, so you're going to have to find the right balance based on whatever enterprise and operations you have at your organization. Then, we see the next thing here, that management's only providing favorable information. And in the Boeing case, the allegations were that there were negative news articles that were coming out, and the board was seeing these negative news articles. And so management would sort of react to that by telling the board, hey, these news articles are totally fake, they're false. The 737 MAX crashes that Boeing was experiencing were due to pilot error, is what management was telling the board, despite knowing of the technical issues with the construction of the 737 MAX that were being reported in these news articles. So this obviously creates a couple of tensions for a board, right? And for your reporting to a board. We want to make sure the board is getting adequate information to fulfill its oversight responsibility, but we also don't want to shoot ourselves in the foot for things like product liability lawsuits. So, I'm certainly not suggesting that we throw ourselves under the bus in our communications to the board, but we should try to, for instance, match what's already in the company's records, so that we're not creating any new information, but we're making sure that information gets to the board. We can use the attorney-client privilege to our advantage here to make sure that sensitive things can perhaps be conveyed in a privileged manner. And then, as always, remember that oral communications are appropriate in some instances as opposed to written communications. Another tension that we see here is that we're asking management to report to the board. And so management, of course, has personal incentives not to self-flagellate to the directors who choose whether to hire and fire management. So here, we want to make sure we have a culture where the measure of a leader is what his or her response is to a problem, and not the fact that the problem has arisen. Finally, I'll fast forward a little bit because I see that we're at our break time here. Another thing the courts are flagging is that management is aware of bad information, but that bad information isn't reaching its way to the board. Now, of course, I'm not suggesting that every last little detail needs to make it to the board. That's not at all what the Caremark Doctrine is requiring, even under this evolving landscape. What's really important is that there's a system in place, some sort of mechanism by which material, important, substantive information will flow up to the board in a manner that's appropriate for the board. So again, if you're Walmart, that doesn't mean that the board needs to get an email every time there's a slip and fall in its stores. That does mean that if there's some systemic problem, or if somebody in middle management whose job it is to attend to slip and falls is noticing some sort of company-wide issue, that information is making its way to the board to fulfill its oversight responsibilities. So I will turn it back now, I think, to Robert to bring us into our break.
All right, everyone. We are going to go ahead and get started with our last panel. I think our team is going to pull us all up Hollywood Square style here in just a moment, but welcome back. For our last panel today, we are really excited to be joined by 3 external speakers who are thought leaders in ESG. So this is my favorite part of the day, where I get to ask hard questions, people who are way smarter than me, and we'll all learn from them. Let me briefly introduce our panelists, and then we'll jump right in. So joining us today is Sharo Atma, the head of ESG at Alyeska Investment Group, a multi-billion-dollar long-short market neutral hedge fund. Susan Gray is the global head of sustainable finance and innovation at S&P, and she's responsible for S&P's ESG and sustainable finance business globally. And Dave Wischel is the senior director at Spotlight Advisors, a financial and strategic advisory firm specializing in shareholder activism and other high stakes corporate situations. So we'll dive right in here. My first question to my panel is this. Last year, we saw environmental proposals that went to vote become the most supported of all ESG proposals, with an average level of support of 42.3%. What do you guys think is driving this dynamic?
In short, it's a pleasure to be on this panel with everyone and to come after such talented speakers. And so it's a real privilege to be able to be the first person to speak. So I thank Maggie and Vianney for that. The short answer to it is investors sort of overnight have changed their position to go from a sort of ignorance of carbon matters to a race to the top on carbon matters. As you alluded to in the earlier panel, BlackRock, State Street, and I'm sure we'll soon see Vanguard are rapidly tightening their policies on carbon and carbon metrics in order to force companies to disclose and reduce the actual carbon metric number that is either disclosed by the company or implied by the company's sub-industry average among its data providers. That's why it's important from our perspective that every company begin to disclose its weighted average carbon intensity. We are, it's something we've begun measuring over the last sort of 18 months here at Alyeska, largely in order to avoid a sense of, or being tarred with the sort of greenwashing brush. And I think lots of index investors are going to begin following suit. Just as a sort of footnote aside, the weighted average carbon intensity that we are measured against and we measure others against is relative to the SPY. Its weighted average carbon intensity is sort of 140, and for you to be lower than average is roughly what we're beginning to think about engaging on and targeting in the next sort of coming months. But that's just one of the sort of key metrics that I think was disclosed by BlackRock at the beginning of 2020, but is going to quickly leak through the capital markets to smaller and smaller players. But more importantly, more and more active investors, we believe, are going to become much more thorough in thinking about what and how a company discloses on its decarbonization pathway, which we're happy to talk about later.
Yeah, and if I can just kind of piggyback off of that comment, I think what Cheryl said about this trend potentially kind of trickling down or trickling throughout the capital markets is very accurate. I mean, if we think about, historically, a lot of corporate governance concepts and environmental concepts have kind of started maybe on the margins, but at a certain level or at a certain point, they become mainstream. And that's really essentially when either the index funds adopt them as kind of core policies and core priorities, or they're enshrined in the ISS and Glass Lewis guidelines in some way. So, we're at that point where you've kind of reached mainstream adoption. And I think, it's really only a matter of time before we see other institutions adopt similar perspective, whether it's kind of smaller index funds or obviously the actively managed funds as well.
Yeah, and I think, just to be even more explicit about it, I think what we've actually seen is that there's now a recognition that climate risk is investment risk, but also investment opportunity. And so that means that, when investors are looking at companies and, there are 130 trillion assets under management of 130 trillion were committed to net zero in some way under the Net Zero Alliance that was formed at Glasgow. So when investors are looking at companies, they are increasingly saying, what is this company's environmental exposure? What are the other, social exposures that this company has? How is it governing these issues? Is it on top of it? Are they looking at opportunities for them as well? What are they doing about it? What do we know? How are we going to think about investing in this company? So I spend a huge amount of my time talking to investors as well as corporates, and they are all spending more time from a stewardship perspective thinking about these issues and trying to work out, not just from a debt perspective, but from an equity perspective as well. How does that impact the company's potential going forward from a risk and valuation perspective?
So, Susan, to pick up on a thread that's in there, in the prior panel, we sort of lightly skipped through some of the changes in climate voting policies that we're seeing from the big investors. And I think right now, from my perspective, it's a little bit hard to tell how much of that is going to be saber rattling as compared to how much of it is real, right? We're getting some very strong statements on, we will vote against directors if we don't think you're taking adequate steps. But then when you really dig into these policies, there's often a lot of, well, we're going to look at climate shareholder proposals on a case-by-case basis. So given that state of play plus this race to the top that Cheryl mentioned, how do you guys think that companies should be changing their behavior this year, either because they didn't get a proposal and they're hoping to not get them in the future, or if they've got a proposal sitting in front of them right now to think about the strategic response?
Well, I mean, speaking broadly on this subject rather than specifically about the proposals, what we're definitely seeing is that investors are looking to understand what a company's strategy is, how its attitude towards climate-related exposures aligns with its business strategy, what are its milestones. If it's talked about 2050 or 2040, what does that mean in terms of 2025, 2030? And then what does that mean in terms of the capex and investment plans of the company, and how is it thinking and communicating around these issues? And so it really, I think, is going to move pretty quickly to the substance of what companies are doing, what is their strategy, how are they executing on it, and this is happening not just in terms of proxy voting, obviously, but also just in terms of discussions that investors are having on debt issuance. I mean, we've seen a trillion raised in sustainable finance issuance in the last 12 months, which is well over double the year before, and we're expecting that to grow. So this is something that is actually quite interestingly moving to a reasonably specific discussion reasonably quickly. Data is improving, so investors are able to get better data to analyze what companies are doing and what their alignment is. This whole landscape is shifting from a disclosure and transparency perspective, accelerated by regulation in other markets as well as here.
Yeah, and just in terms of what this means kind of at a practical level for issuers, I think it's increasingly important to kind of pay attention to the signals that you're receiving from your investor base. If you're an S&P 500 company and you're engaging regularly with your shareholder base, odds are that these topics are coming up in discussions. Your investors are asking questions about your disclosures and your targets and things like that. And, you may not be part of those conversations if you're a director or in certain executive roles, but that information should be eventually making its way back to the board. What are investors saying? What questions are they asking? Are we providing enough information or the right kind of information? Typically with these policies that these investors have in place, the practice is to, engage with the company first. And if that engagement isn't showing results, then you start, then they have, voting consequences. But, the other thing obviously to look at is the voting results every single year. If you have a director who's suddenly receiving, 15% less, support than they're used to receiving, we should, dig into that and engage with the investor base accordingly.
I read a study, to David's point, earlier this month, that one of the biggest areas of demand for company personnel as well as board directors are ESG competent directors. And I think that's largely driven by investors from the index funds, and now more increasingly from active funds, asking the question, well, how does your board oversee climate and other ESG matters? And having a respectable answer, a respectable metrics-based answer to that, I think was being able to say vaguely, oh, well, we're looking into it, or we're forming committees throughout the end of 2020 and throughout 2021. But as we begin to enter 2022, investors are beginning to sort of sharpen their pencils on specifically what issues they're going to be asking about, specifically which issues within E they're going to be asking about, whether it be net zero, whether it be assurance, whether it be, are you going to get there on scope 3? And I'm sure we'll talk about those things. More specifically, sort of disclosing that and setting targets for yourself on a go-forward basis. And from our perspective, because we've been asking these questions for the last 2 years, I think in our hunt for relative value and relative competence on these points, we look for companies that are trying to get ahead of their peers and disclose these issues and generate the competence before they're either forced to do so by regulation or through private ordering by the large index funds.
And Maggie, if I may just add to that, I think that we've gotten to a point where it's very, very clear that this is absolutely about governance, and E and S and G are all inextricably linked, and good governance is about managing these issues effectively. So, so from our perspective, when we're looking at credit ratings, this is an aspect of the management and governance element that we look at. And then in our ESG evaluation, where we look at the preparedness of companies for risks and opportunities of the future, we speak with a member of the board, and we actually have governance weighted at 40%, E and S at 30% each, because it is the all-embracing framework for stewardship of the company, and that's ultimately what this is really about.
So Susan, I think that the governance point is a really interesting and important one. As we've gone into this season, we've obviously seen a lot of focus on net zero. And I think one way of interpreting that is it was really easy to say those magic words last year. And now it's really, really hard to figure out what are you actually going to do. And if we look across both the pledges that corporates have made and then how asset managers are talking about net zero, we still seem to lack a commonality of language there. And so I'd like to throw this back to you to start and just sort of what are you thinking about? What are the biggest issues that you see with net zero going forward, and how is that going to play out?
Well, as you say, I mean, there are different standards in different regions, different expectations. Every sector is different. Every company is different. So it is, so absolutely that is one aspect. But I think that what this ultimately comes down to is companies having a clear strategy, communicating it to the market. They may decide to align with science-based targets. They may decide to publish milestones. They may decide, to disclose scope 1, scope 2, and scope 3. But also there is this whole thematic around what's your plan? Where are you going? What are you doing? How are you going? How is your business changing or not changing? What are you doing with your supply chain? What are you doing with financing? And so there is this need in a way to, it's one thing to rely on performance of the past, but the focus has now shifted to preparedness for the future and the future trajectory of the company, and communicating that effectively to the myriad of investors who are starting to ask. And as you say, it's not just the largest investors, it's also small and mid-sized investors, and it's actually consumers as well. I mean, this is all stakeholders that we're talking about here that are interested in this area.
So on net zero, Maggie, you hit the nail on the head. In terms of net zero promises, there are approximately 15 or 16 different versions of the net zero promise that are out there in the marketplace. I'm not making that number up. It's a real number. You should go to the Oxford Net Zero Initiative if you have not, and you can see all the various different categories. One of the sort of undercurrents here that I think is not fully appreciated yet by issuers is that all of their coverage banks, particularly for the large issuers, are beefing up their ESG frameworks and their ESG metrics. because of client demand. So if you haven't seen your active investors, your active hedge funds, your active long onlys that are inside of your shareholder base ask these questions in a sophisticated way to date, it's not because they're not paying other people to study that question right now. They definitely are. And those desks are beginning to publish dedicated ESG notes. And to steal a quote from this morning's SSGA letter, promulgated by, I think, some of my old colleagues, this is about value, not values necessarily, largely because, the risk of having stranded assets is so large for some companies, whether those assets are stranded by climate change or whether those assets are stranded by market change. And so thinking very carefully about whether you make the capital N, capital Z net zero promise or some other type of promise, GHG neutral, carbon neutral, 1.5 degree aligned, needs to be a serious decision that you make, one that you will probably have to make at some point in the near future, and be thoughtful about what you say on that front. Just from our own active approach right now, we're asking companies, what their board oversight of climate-related risks is, but also what and whether they disclose their Scope 1 and Scope 2 GHG emissions to the Carbon Disclosure Project. Usually we know whether they do or not when we ask them that question, whether the number is published via an industry average or whether it's a unique number inside of the various data sets helps us understand. But for the issuers out there thinking about that metric, it's probably best to not be tarred with your industry average at this point. But I'm sure it's a strategic decision for every issuer to make.
So one of the things that frequently arises when we advise clients who are thinking about making or implementing net zero pledges is, should I say those words because it's going to make people happy? And generally our advice would be, please don't do that if you don't know how you're going to get there. But that can mean a lot of different things, right? Embedded in that is, do you really know what your emissions are? Do you know what all of the scopes of your emissions are? Have you thought about offset supply, right? Because I think we see a lot of these pledges that in many ways are going to rely on either technologies we don't have yet magically becoming available, or buying a lot of offsets in a market that is currently really fragmented and frankly without a lot of regulation or perhaps enough supply. And I'm just wondering how you think about assessing those issues and thinking about whether a company can execute on their strategy.
So from a company's perspective, there's a lot of information that is being published about companies and a lot of assessments that are being made on as Sharon said, at the sector level and the regional level already. So I think that is an important thing for companies to be aware of, that if you're not actually actively involved in this, decisions are probably still being made by investors and index funds around what they think your profile is today. This is an area that we're hugely focused on at S&P Global, and we have a climate data and analytics company that we bought called Trucost a number of years ago. We just announced the acquisition of the Climate Service. And we look at this data. We also get a lot of data from companies through our corporate sustainability assessment survey process, and so there's a lot of analytics around this that is already going on. It's worth participating in from a company perspective because it's flowing into so many indexes today that it really is starting to impact how they're perceived potentially by investors, and they can, they can really kind of understand where they sit and think about their strategy more in a more informed manner if they really, can see where they sit relative to peers and others, and that's certainly what I've heard from many companies that we've been talking to over the last couple of years.
I'm glad Susan brought up Trucost and the CSA because we work with a lot of companies that are not in the S&P 500 who want advice on whether they should take the time to fill out the CSA and what this company Trucost is saying about them, or what CDP is, for example. And to those companies that do not fill out the CSA, you should definitely do so. Largely because you're going to get implied scores anyway, very likely. Having dug into the sort of data industrial complex on ESG quite a bit, Trucost is one of the leading carbon analytics providers to folks. So even if investors don't buy the overall S&P score, they will buy separately the Trucost score, because it's one of the sort of better carbon analysis scores. So Trucost is a sort of salient name that people should know and understand. But even the Trucost scores are still 60 to 65% implied data, which is really fascinating, which means that roughly only the sort of top 5% of companies are providing full disclosure data to Trucost and through the CSA sort of analysis, which is not to say that you need to fill out every piece of paper that you're ever sent as a company. I think investors understand that, you want to fill out and think about items that are material to your business. Right now, there's one leading voice in the US at least, for materiality items as to companies. That's the SASB, so that's soon going to be the ISSB board. That's a great initial benchmark to use. But even for the SASB items, we don't expect you today to fill out every single SASB item, right? At least from our side, there are going to be things that are hyper material to your earnings in the near term that are useful to fill out and think about. At this point in time, so long as you make a good case for what you are doing and are not doing, that's great for now. We're looking for progress and not perfection at this point.
So I want to follow up on this data point, but before I do, I forgot to mention at the top, if there are any audience questions, please feel free to submit them through the chat and we will do our best to address them. But following up on data, Cheryl, you mentioned this sort of rise of the data industrial complex, and there are any number of entities out there now who will offer ESG scoring, right? And some of it is based on information solicited from companies like the CSA. Lots of it is based on web scraping. And so, the data varies in terms of how precise it is to the company. It varies in its quality. And we are increasingly seeing funds and other entities trying to use all that data to make statements about value or form theses about how they're going to get returns. And I'm curious on y'all's views of whether we are generating sort of both more and less data than are useful, right? Because we have a lot of information that's out there now, but I do wonder, do we have the right skill sets to actually evaluate it and use it in a way that's going to generate returns, which is the theory behind all of this?
Well, I can start on this one because I think it's a great question, given that I think the other thing that's happened is that needs have changed very, very quickly. And it also goes back to what Dara was just saying. We at S&P Global, we are very focused on getting as much integrity and accuracy into our data as possible. And so the 2,000 companies that fill out the CSA have the choice as to how much of the data that they share with us is brought into the public domain. But it does give us as well as the Trucost data, it does give us a significant amount of data from companies which we're then able to verify and make sure is accurate and then supplement that with other data sets that we're able to get. But I suppose to your point, we're also getting, better satellite data. The sources of data that are coming into this analysis are getting increasingly just getting so much more focused and interesting. And so I do think that we are just on this continuum where we are going to get more and more clarity around climate impacts from better data analytics, particularly around physical risk over the next few years. And that's going to start to become more and more pertinent to investors' decisions around risk. So it's a very interesting time. It's moving very quickly. But there's a huge effort going into it, and the company engagement piece, I think, is, as Shara was saying, is really important, because it's a bit of controlling your destiny to some extent.
So folks have probably worked over the various SSGA, ISS, and BlackRock letters over the years. So I'll introduce two more notes that you should think about as you're thinking about whether there are financial ties to ESG metrics. The first is AQR's notes on the efficient ESG frontier. They've put out a lot of research associated with the use of data and thinking about whether ESG does contribute to returns, and they come to a very similar conclusion that we do, which is why head of ESG positions are sort of proliferating among active managers. I would also take a look at Bridgewater's work on ESG matters. Some of it is marketing oriented, but there are a few core papers that tie ESG metrics to returns. Just so that you don't think it's, me quoting only long only or passive investors. There are folks out there in the active long-short management community that are really thinking about this. And finally, on the longs versus the short points, Cliff Asness from AQR said, hey, guess what? One day very soon, we're going to need to initiate shorts on the basis of climate matters and on the basis of ESG matters. And so typically when Cliff Asness says something, he means it and has a large weapon to wield associated with it. So I think we're just at the beginning of tying financial return to ESG metrics, and that it will only proliferate over the next decade plus.
Yeah, and just to add to that, I think there's no doubt that the data is becoming more and more expansive every single day. Whether it's all kind of decision useful is another matter. I think the next challenge will be how do the markets utilize this flood of data that's coming through to make these decisions? And just tying back to what we discussed earlier, these kind of ESG focused priorities, maybe starting with the index funds, but they are trickling down to smaller and smaller funds who maybe don't have the same resources in terms of stewardship teams, in terms of people who are actively looking at this data and kind of parsing it at a human level. The concern that I would have is that, in an effort to kind of emulate BlackRock and Vanguard and State Street, you have other institutions who are doing this on a maybe excessively quantitative basis, where they're, overly reliant upon ratings or, even just data, not necessarily the rating system, which I think is a little bit of a slippery slope once that data begins to kind of guide voting decision and investment decisions, and then the kind of human oversight element is divorced from it.
So Dave, following up on that, I think we here all have very particular perspectives on the need for real people with real expertise to play in this space. But what are the big trends that you see in ESG data and how people might try to use it in an offensive manner?
Right. So I think we are in the very, very, very early stages of investors and activist investors in particular utilizing this data in public campaigns. Now, I want to kind of be careful to point out, the ESG factors are not going to form the fundamental basis of an investment decision or investment thesis for an activist. At least for 99.9% of the activist universe. Yes, it's a factor for engine number one and Impactive and funds like that, but the vast universe of activists is not really looking at this data in any meaningful way. What I would say, though, is that you do have a subset of activists that are becoming a little bit more sophisticated in how they are presenting this data and kind of using it as a tip of the spear. In the same way that, do activists really care whether you, allow shareholders to call special meetings or act by written consent or, have supermajority voting thresholds? Not really, but they know that other investors care about that. So that's why you see it in these investor presentations, these fight decks. And I think, frankly, with a few notable exceptions, or at least one very notable exception, I think that's how ESG data is going to be used by activists for the foreseeable future. It's a single page in the fight deck. It's a couple lines in a fight letter. It's not going to be, the basis for a campaign in most situations.
And do you think that will hold even with all of the policies we're seeing now that say we might vote against your directors if they're not doing what they need to do on climate? Or do you think we might see a build out of a multi-year strategy where we start to see a push around some of these issues where the bigger asset managers have committed to maybe changing the way they vote on directors as a wedge strategy?
Well, I think from an activist perspective, again, I don't believe they truly care about those issues in most respects, but if they look at the voting results for the past 2, 3, 1 year, whatever, and they're noticing, oh, this company, all the directors are only receiving 72% support, or, they went from 99% to 63%. What happened? That's a vulnerability. That shows, there is investor discontent here. And they're going to be asking themselves, how can I leverage that to achieve my own goals? Now, they might be totally different from what the basis of the against votes, but that's just that is a fundamental thing that an activist would look at, I think.
So following this point of data, Susan, it already came up that S&P has recently acquired the Climate Service, and you are certainly not alone in acquiring smaller ESG data providers. And I'm just curious what you think the big trends in the ESG data space are going to be, and if we'll see a continued consolidation of service providers and what that might mean for the market.
Well, as I said before, I think that the big trend is that there's going to be more and more focus on what companies are doing around ESG generally, and it's not just climate; it's social as well. And really understanding not just the performance of a company, but where it is going in the future. And so, for that reason, there's definitely a significant amount of momentum in this space, and the focus on disclosure. We're very committed to this space. We're expanding our activity very significantly, and will continue to do so post the upcoming merger with IHS Markit. So I think we're certainly seeing this as a space which is increasingly being one that investors are taking into account when they're thinking about valuation and pricing. So absolutely, it's going. That momentum is definitely going to continue. And on the flip side, greenwashing. It's the flip side to, I think, David's comments earlier. Increasingly we are seeing that when companies are going into the market with debt issuances or claims when they're looking at capital raising more generally, that is getting a lot more scrutiny than it possibly did in the past as well from investors.
I mean, from our perspective, we always view it as such a shame when we know what a company actually does, right? We're active managers. We have the opportunity to dive very deeply into a handful of names a year, which is a real privilege. I mean, it's a real privilege to be able to do that. And it's always a shame to us when we see, Rater XYZ has put you in their bottom quintile bucket sort of accidentally because you haven't responded to them over the years, or because some index has driven you in a certain way, which is to say, disclosing the right things at the right time is what they want, and a knowledge of what these large data providers use as their maps, which is and can be very complicated, is essential so that you don't kind of feel like you're wasting your time and do in fact wind up wasting your time as a result of trying to map to what these data providers want. But to the earlier point about sort of active qualitative management, it is one of the key things that I think is going to be the lifeblood of active managers coming in the next few years. As you know, active managers are faced with many headwinds from the sort of indexers, right? ESG has a lot of qualitative analysis, and there's a lot of wood to chop ahead of us in figuring out ESG matters. It will be the ken of, and it will be advantageous to companies who help convince their active managers that, hey, the large quantitative scoring systems just are not keeping up with what we are actually doing on the sort of long side. And on the short side, if what you're saying does not match what you are actually doing, it's very likely you're going to be targeted by someone like Spruce Point, right? Who says, hey, what you're saying about your XYZ polymer or what you're saying about what's inside of your consumer product that you're selling is not true, and we're going to publish a 37-page report on it. And the marketplace respects folks like Spruce Point and needs them as a price clearing device on ESG matters. So on both the quantitative and the qualitative front, at least on our side, because we're long short market neutrals, we study all of these things. We are indeed noticing premiums associated with companies that really do ESG matters. And I think while in 2019 and 2020 it was the year of if you make AAA, then you're going to outperform, right? Throughout 2021, that sort of flattened out that strategy in terms of actual economic return. And I think through 2022 and 2023, you're going to begin to see, hey, these are the folks that really do it, as opposed to jawbone it, expand their multiples.
Maggie, maybe I could just add a point on this qualitative piece, because it is a really big deal, as Shara says. And one of the things we've done as a response to both companies and investors wanting that sort of further forward-looking deeper dive is to develop the ESG evaluation, which we've done we've got about a couple of hundred that we've completed or have underway now, where we our analysts, our 1,500 credit analysts and our 60 sustainable finance analysts who actually understand the sector and the company sit down with the company, and we talk to them about their strategy, the opportunities they see, what they're doing around E, S, and G, and provide a report that they can either use to communicate with investors, or if they want to, they can keep it private and just continue to, work on their journey. But this piece around, to Shara's point, performance is one thing, but the future strategy is becoming more and more important, and getting that out to the investor market in a way where you can talk to smaller investors as well as the large funds is really going to become increasingly important.
I would say there's one throwaway line, to Susan's point, inside of SSGA's letter this morning that says reporting and assurance, which I think might be underappreciated by lots of people reading the letter. It's mentioned twice very quickly. I think it's the sort of early phase of State Street saying, okay, voluntary disclosures with the we believe you front era is beginning to end, and the assurance and forward-looking strategy implementation, pari passu with financial disclosures, is kind of the wave of the future, which means that you really got to get your footnotes in line on your ESG stuff, which sounds really boring, but it is what it is.
Well, I think that ties back to what you said earlier about multiple expansion or just multiples in general. Really, what we're talking about here is management credibility and shareholder trust. And while you might not necessarily agree with the statement that ESG is material to performance, but I think almost everyone would agree that you can have a management trust premium or a management trust discount, and that ties to everything from the statements you make on earnings calls to the footnotes in your disclosures. And if there's not consistency between what you're saying and what you're doing, eventually you'll get found out, and that's where that discount comes into play.
And I think the other point here that's important is that ESG is I mean, we're talking about supply chain. We're talking about talent. We're not just talking here about climate. We're talking about changing consumer preferences and where that's driving, product development or the way companies are transacting. It is a very holistic approach, and it really is trying to say, what are the externalities that may not be currently valued or completely valued, but could actually have a material impact positively or negatively in the future. And that's what ESG is really trying to pick up. So it's a question of, how you measure that impact on value, probably as distinct from, does it have a potential value impact in the future? The statistic I really like is that if you look at the S&P 500 over the last 70 years, in the 1950s, the average life of a company on the S&P 500 was 70 years. Today, it's about 12 or 15. And that just shows you, and obviously there's M&A, there's a whole bunch of things influencing that, but you can't stand still, particularly in the world we're in now, as we all know.
So let's pivot from there, since we are the last panel in a proxy season preview CLE. Dave, I was hoping you could talk to us a bit about one of the biggest events of last season and maybe walk us through the Exxon engine number 1 and what that might mean for how folks are changing their approach to active situations this year.
Sure. So the Exxon and engine number 1 campaign has gotten a lot of press, obviously, and rightly so. Interesting to note that it was the only proxy campaign that was lost by management over the last proxy season. Dissidents had a very bad track record in 2021, and that was kind of the exception. But I think it should give our issuer friends on this call some comfort to know that I don't think that will be a kind of harbinger of campaigns to come. I think that campaign really only worked at ExxonMobil, and there are maybe a handful of other companies that are really susceptible to that kind of a campaign, just due to the shareholder base, the kind of level of notoriety that the company had around climate and that sort of thing. I don't see too many other activists kind of jumping into that sort of level of campaign, because it's very difficult to do in most situations to kind of tie climate risk back to historical performance, back to future capital allocation decisions. It really only happens in a small kind of subset of industries. But what I would say is that increasingly activists are asking our clients questions about how are you going to disclose your risks and opportunities related to this fundamental change that's going on? So, just to use an example, electric vehicles. If you are a fuel supplier or a payments processor that has a big kind of transportation clientele, those are potential material risks to your business, and investors need to be able to kind of dimension those risks and opportunities. And determine whether the board is kind of allocating resources appropriately to those opportunities and overseeing them appropriately, and whether they're kind of reflected in the strategy. So again, while I don't see, there aren't a lot of engine number 1s out there, it's kind of becoming integrated with the rest of the investment universe, and it might be, one prong in the campaign, but it's still something you kind of need to think about.
Yeah, I think David hits the kind of nail on the head here. If you are not dimensioning your risks and opportunities for your investor base in peacetime, they will be dimensioned for you shortly before peacetime ends, largely because folks are just facing pressures on these matters. It's no longer just the companies facing these pressures, it's investors facing these pressures, traditional investors facing these pressures from the people who commit capital to them. And, at the index level, the people who sponsor their indexes. So it's not just you folks feeling it, it's the investors feeling it too.
Yeah, I mean, the thing that we often hear from our clients is that, look, we are investing, we are paying attention to these new opportunities and new risks. But the fact of the matter is that if you're not talking about it, people are going to assume that you're not doing that and that you're not kind of, looking forward and adapting your strategy accordingly.
So for my final question, I want to take it just a little bit broader because we've spent a lot of time focused on climate because that has been a huge area of activism. But when you look across ESG and you see the kinds of proposals that are out there, right? We have proposals on diversity, we have proposals on plastics, we have proposals on supply chain. There's a lot of different things in there. And even, Dave, to your point about EVs, right? Maybe you have a real climate opportunity in the EV space, but maybe you have a real human rights risk depending on where your component pieces are coming from. And so I think one of the real challenges we see for corporates is that it can be easy to be like, oh my God, an investor wanted to engage with me on climate, so climate is what I should focus on, and get a little bit of a blind spot to the issues that aren't being pushed on right now. So a two-part question for y'all. The first is, beyond climate, what are the issues you're watching this year and expect to become bigger in 2022? And how do you, in your roles, think about how companies should make that trade-off in terms of where they invest the level of effort if they really can't do all of the above on ESG?
Shall I start? Okay. So I think that Dave's point is the key one. What is material? What are the material risks? What are the material opportunities for your business? And thinking about that very clearly and thinking about how you can analyze that and how you can assess that, because obviously that is, at the end of the day, ESG strategy and business strategy really need to be aligned, and ESG strategy should be supporting your business strategy and helping your business grow. And that's certainly the way that we approach the analysis, particularly in the ESG evaluation that I mentioned earlier. In terms of the areas that we're kind of particularly thinking about at the moment, the supply chain is just getting more and more attention because over the last 12 to 18 months and right at the moment, the issues around supply chain have kind of gone into stark, fallen into stark relief, and there's obviously a geopolitical element to that as well, which is really important. A lot of impact potentially from changes in regulation. There's a lot going on in Europe that is flowing into companies here. I mentioned greenwashing as well as something that is an increasing focus of companies and particularly the intermediaries, bankers that we're talking to in terms of how they support clients going into market. And I'm sure it's something that you focus on a lot too, Maggie. And then finally, I think the other piece is just talent, diversity, DEI. That area is and this is all aside from climate and nature-based solutions. I think they're the kind of areas that in that sort of non-climate world are particularly at the forefront at the moment.
I would take Susan's point about index turnover just one step farther. That statistic should really resonate with every issuer that we're speaking to, because investors are being demanded greater idea velocity. The information revolution has finally become the idea velocity revolution inside of investors framework. And so the question I have asked is, how are you future-proofing your business? Period. And sometimes it catches people off guard. I guess it won't if you're listening to this call, but letting us know, hearing from a business what initial couple of lines come out of their mouth when we respond to that, whether it's we're taking really good care of our people or we're being really thoughtful about capital allocation, will help determine the tone and tenor of those conversations. If someone responds with, what do you mean? That might be a different type of conversation.
Yeah, and I just want to point out that a couple topics that are kind of conspicuous in their absence from Susan's response, and that's compensation and governance. And that's not to say that they are going to be spoken about. It's that they're really no longer spoken about for the most part. I think it's really incredible to see how these engagements have kind of evolved over the last 10 years or 11 years, I suppose, since Say on Pay was implemented. People are sick of talking about it. They don't want to hear about CEO compensation anymore. By the same token, investors have been publishing their policies on classified boards and things like that for years. If you don't know what their expectations are by now, that's kind of a problem. So really, I would say that it's rare, unless there was a serious Say on Pay problem, to have those be the foundation of off-season engagement. We're really kind of shifting into a very different area, and I think it's important that boards and companies kind of evolve accordingly.
Well, that brings us to the top of our hour. Thank you so much to the three of you for joining us. It's been a really fun conversation, and thanks to everybody who's been watching.
Thank you for having us.
Thank you.